ENVS 200 Assignment 2 Recorded Presentation, The Role of Indigenous Knowledge and Its Relationship to Environmental Law by Madison Riddell. So what is Indigenous knowledge? Indigenous knowledge can be a complicated term to define. It can mean something different to everyone. For the most part, Indigenous knowledge can be seen as a complex system of knowledge based off of the worldviews that Indigenous peoples have. It is the skills, philosophies, and understandings related to the natural surroundings of Indigenous people and their communities. Indigenous knowledge can be a tough term to define because of the uniqueness and different perspectives on languages, cultures, histories, values, legal systems, and governance of Indigenous peoples. Indigenous knowledge has always been built upon earlier generations' knowledge and their past experiences. Indigenous knowledge continues to grow as the days pass and society changes. It is widely known that Indigenous knowledge stems from and deeply involves having a relationship and living alongside the natural world. Indigenous knowledge is different for all First Nations, Inuit, and Métis communities. They each have their own distinct way of growing and describing their knowledge, which knowledge keepers or knowledge holders in each community can do best. It is important to highlight and understand that Indigenous knowledge in some communities struggle at maintaining their expertise because of the past and continued harm and colonialism that has occurred/occurs. What is environmental law? Environmental law is a set of laws, agreements, regulations, and common law which govern human interactions and impacts on the environment. These laws have been set in place to protect and preserve the natural environment. Environmental laws and regulations in Canada can be passed through either the federal or provincial governments. Federal environmental law. Through the Constitution, the federal government has the power to pass laws relating to shipping, interprovincial trade and commerce, fisheries, and criminal law. Some legislation that has been passed through the federal government include the Canadian Environmental Protection Act, the Canadian Environmental Assessment Act, the Pest Control Products Act, the Canada Shipping Act, the Arctic Water Pollution Prevention Act, the Fisheries Act, and the Transportation of Dangerous Goods Act. Each legislation is in place to protect the environment on Canadian territory. Provincial environmental law. Local property and nature, along with civil rights within each province, are provincially regulated. Each province also has primary jurisdiction over forestry, agriculture, mining, and hydroelectric development. Because provincial governments also own most local natural resources, exploitation of these resources tend to include systems which protect the environment. Each province has passed legislations on water pollution and air pollution. Most wildlife conservation and management regulations and the creation of wilderness areas and ecological reserves also fall under provincial legislation. Overall, environmental law is something that protects the environment from the harms humans may cause it. Environmental law became a type of law because of the irreversible harms, effects, and injustice the environment has felt in the past. What is Indigenous environmental law? Indigenous environmental law commonly acknowledges the deep relationships that Indigenous people have to the spirit world, the land, and water. It is the basis for environmental management and governance within Indigenous peoples' territories. It is Indigenous peoples' own legal system. Comparing environmental law and Indigenous environmental law. Some similarities. Both environmental law and Indigenous environmental law want what's best for the environment. Both legislations work to better the local environments, protect it from further harm, and work to make up for the harm that has been caused in the past. Environmental law and Indigenous environmental law are each a type of legal system that is enforced. The jurisdictions and legislations both consist of laws, agreements, regulations, and common law. Differences. Environmental law can be passed through both the federal government and/or provincial governments in Canada. Indigenous environmental law is not federally or provincially passed through legislation. Environmental laws can be enforced by authorities like the police, RCMP, and conservation officers. Indigenous environmental law is a type of legal system enforced by Indigenous peoples. Environmental law has an overall interest of the environment. Indigenous law, however, is all about the environment. Often, environmental law also wants what is best for people, the economy, and society. Indigenous people do not practice this and hold Mother Nature sacred and puts the environment first, no matter what.